next topic is repairs. The repair law in Texas is called the warranty of habitability. It basically says landlords have a duty to repair conditions that affect the physical health and safety of ordinary tenants. Flooding, plumbing, leaking, mold, infestation, lack of heat, lack of hot water, lack of air conditioning, of course, if they're providing that. And so if you're a tenant and you have a condition that develops that is a threat to health or safety, you have to do a couple of things in order to activate the repair law. You must be current and paid up on your rent and other fees, and you must request those repairs in writing. And the leases typically say that that notice has to be written and signed. So when it says written and signed, that tells me a piece of paper, old school letterhead. You want to send it by certified mail as a speeded up process, or you can hand deliver your written request. And if you do, ask them to sign your copy as proof that they received it. Sometimes managers come and go, staff comes and goes. The person that you're talking to today may not even be there tomorrow or the next day. But if you have an impeccable paper trail, those people who come in after have to follow through on that. You don't have to start from scratch just because there's a new person in that office or a new manager. So make sure that you are paid up, make sure that you have a paper trail. Depending on how you send it, you can have a speeded up process that only takes one letter if it's by certified mail, return receipt requested, or registered mail, or some other trackable form through the post office or private delivery service. And again, if you hand deliver it, get them to sign your copy. That means that you'll have to send them 2 written requests. If they fail to remedy the problem within that reasonable 7 days, then the law says that you have a number of remedies available to you. One is the right to terminate the lease, to protect your credit, your rental history, and to get your deposit back. You're also entitled to take them to court for a civil penalty of 1 month's rent plus $500. Your damages, which includes or can include your moving expenses. Another option is to use the repair and deduct law, which means that you can follow a procedure that allows you to hire qualified people to make those repairs and deduct that amount from the next month's rent. It's not withholding, it's repair and deduct. You can't do the work yourself, even if you're qualified to do so, and you can only use 1 month's rent or $500 at a time, whichever is greater. So you need to follow that procedure that can allow you to repair and deduct. And the last option is called the petition for repair and remedy, where you can actually continue to stay in your home, pay your rent, and take your landlord to court. You are the plaintiff, they are the defendant, and you can get a judge to direct the landlord to make those repairs. You're also entitled to a percentage of your rent money back based on the date of your first request, as well as a decrease on your rent until they make those repairs. So tenants have options, they have rights. Landlords typically are not going to acquiesce or say, fine, you can go. So that means that you need to be prepared for them to push back. That's why you need to make sure that you've got all your I's dotted, all your T's crossed, so that if they try to challenge your right to pursue those legal remedies, you're going to have what you need to prevail.